There comes a point when clients do want a pit bull. They want an attorney who is going to zealously advocate for them. And just because that's not the approach we're taking in the beginning doesn't mean that we can't flip that switch and go down that aggressive pit bull win, win, win in court mentality. What we do is we start every single case with two piles. Is this one that's going to litigation? And is this one that maybe can be solved pre-litigation? We work both cases up as if we were going to court tomorrow. May it be an event that ends up in court or could end up in court. We prepare for the possibility that we are going to end up in court. However, do we take this case as a conciliatory matter, trying to find a solution and work with the other side if you have two people who can work together? Or do we realize that the other person isn't going to work with us, or that we're never going to meet a common ground? And then we switch from a conciliatory type to more of a litigation style. And the litigation style is sometimes necessary. Sometimes you have to litigate. At the end of the day, there's a reason that there's the person in the robe that sits and listens and passes judgment on the facts, and they're there for a reason and they have a very important part. While 95% of all cases settle, there is still the 5% that don't. And for years and years and years, we strived on those 5% of cases. While we haven't turned our back on those 5% of cases, we realized over the years that there's a more cost-effective way, there's a more reliable way, and a more controlled way of controlling the outcome by trying to negotiate a settlement versus coming into court and litigating. And oftentimes, through solid, sound litigation, we can reach a settlement prior to trial and give or get the clients the result that they want. But we have no problem flipping that switch from conciliation to litigation.